The defense in the Lindsay Clancy murder trial called multiple witnesses today, including her ex-mother-in-law, Susan Clancy. Lindsay Clancy has admitted to killing her 3 young children in January of 2023. She has pleaded not guilty to murder charges, arguing she had postpartum psychosis, bipolar disorder, and was overmedicated. Here is some of her ex-mother-in-law's testimony.
She was very nurturing, very loving. She was a wonderful mother. Wonderful.
Did you find at all, do you have an opinion with your observations of Lindsay as to whether or not she was offered help and would just spurn it and not see doctors and not have
She was
treatment?
begging for help.
Begging for help. CBS News legal contributor Jessica Levinson joins me now. So, Jessica, as you know, and we've discussed, the courtroom is about the facts and the law. But trials sometimes carry on larger conversations in America, and there's sort of a multi-layered conversation going on about this trial. One that talks about postpartum psychosis and its reality. A conversation about the mental health care system and can differing doctors miss certain things or overlook certain things. And in the process of trying to treat someone, can you over-medicate someone to the danger of them or possibly their loved ones? A lot is going on here. Your thoughts?
Exactly as you said, that this case is taking on more than just the tragedy at hand. We are having a conversation about mental health issues that people can experience after having children, postpartum psychosis. We are having conversations about the mental health system. And frankly, I think the defense is putting the mental health system a bit on trial in the sense that they're saying that what Clancy received was this fragmented treatment that did not truly treat her and that did not truly understand the depth of her pain and the depth of her illness. And what they're seeing is that she saw a couple of people over Zoom, even one mental health professional, the psychiatrist, the day before this tragedy occurred. And what the defense is arguing is basically everybody missed it. And I think what they're saying underneath is that she is not the only one, that this could happen to somebody else as well.
Of course, the state is saying, yes, that might all be true, but that's not nearly enough. And under the law, there's a serious crime here, and it must be prosecuted to the fullest.
Well, that's right, because we know that saying I am suffering from a mental illness, even if it is a very serious one, is not enough to release somebody of criminal liability. When it comes to this particular case, what the prosecution needs to show is that she was able to form the intent necessary to commit these crimes. Specifically, when it comes to this defense of, we commonly think of it as not guilty by reason of insanity. But what is happening in Massachusetts is that the defense wants to show that she was not able to form the intent necessary because she was suffering from a mental illness that caused her to be unable to conform her behavior within the bounds of the law or to understand the wrongness or criminality of her actions. Those major, as you know, are very high bars. It's much more than I'm severely depressed or I have bipolar disorder or even I have borderline personality disorder. If we had a system in our country where saying I'm suffering from a mental illness, therefore I cannot be guilty of a crime, obviously that would look like a hugely different criminal justice system.
About 25 seconds, Jessica. There have been some comparisons online to a 2001 case involving Andrea Yates. Legitimate?
Well, in terms of the broad brush of the tragedy that happened in both cases and the fact that the mothers who killed their children were saying, I'm suffering from mental illnesses, fair. Are there, as you know, significant factual differences between the two cases? Absolutely. Is that enough to make a legal difference? We have to wait to see.
We have to wait and see. Jessica Levinson, always a pleasure. Thank you so very, very much.